Hi, my name is Veronica Young and I'm an associate at the Feldstein Family Law Group. In this video, I'll be going over 3 common myths about separation and divorce. First off, women always win in family law. One concern I hear from clients very often is that women always come out on top in family law. There's this prevalent idea that Ontario and Canadian family law regarding spousal support, child support, custody, and access generally favors women over men. This is a popular misconception, and I'm here to tell you that it's generally untrue. The law and the courts are neutral. Both parties, whether they are men or women, breadwinners or homemakers, both have rights, entitlements, and obligations in family law. Generally, whether a man or woman wins in family law courts depends on the particular facts and how the law applies to those facts. Every case is different. Every case is unique. But really, the reality is that there is no such thing as winning or losing in family law in general. Taking a win-lose approach in your family law matter ends up with both parties losing a lot of time, money, and sleep. The win-lose approach is damaging to you, your wallet, your sanity, and your children. It's not the approach you should be taking. Family law is about compromise and settlement. You and your ex, and your children especially, all win if both parties try to negotiate a resolution that is best suited to your unique case and family circumstances. The second misconception I want to talk about is, my kid only wants to live with me, so the courts will make it so. Nope. In family law, there is something called the maximum contact principle. While this principle is enshrined generally in the Divorce Act, it also applies to unmarried parents. Essentially, the courts want to maximize a child's contact with both parents where the parents are decent parents and are able to care for their child. The child's wishes and preferences are not always paramount because children do not always know what it is that is best for them, or they may be parenting another person's desires. Whether a child's wishes and preferences are considered by the court in a custody access case depends on the child's age, maturity level, and whether the court suspects that one parent is negatively influencing that child's refusal to see the other parent. The last and final misconception I want to talk about is, I don't need a family law lawyer. Of course, every family law lawyer will tell you to retain counsel at the start of your family law matter. But do they really tell you why? Essentially, going through the court process is time-consuming and complicated, both procedurally and legally. Negotiating a resolution outside of court can similarly be complicated, especially when you are not familiar with the law and what rights, entitlements, or obligations you may have. Many self-represented parties start the court process or negotiation processes themselves. Often, these self-rep parties only retain counsel when they become stressed, overwhelmed, or confused by everything that's going on. By this time, these parties may have inadvertently hurt their own case by prejudicing themselves. Retaining counsel to represent you from the get-go, or to at least provide you with legal advice and opinions throughout the process, can help mitigate unnecessarily complicating your matters or causing yourself problems down the road. As I mentioned before, family law is about compromise and settlement. As a family law lawyer, I want to help you be able to move on with your life. Essentially, our job as family law lawyers is to help you resolve your matter in the most amicable, timely, and cost-effective way possible. We're here to lessen your stress. We're not here to make it worse. So, that's all for today, folks. If you would like more information or to book a consultation with one of our lawyers, please check out our website at www.separation.ca or call us at 905-415-1636.